So I was a GDL student when I was applying to families law sets, and it did affect the way that I prepared. I was very conscious of needing to establish the basics. So we didn't do family law on my GDL. It was something that I developed sort of extracurricularly in my own interests. And so maintaining the key legal principles was something that was very important to me and something that stood me in really good stead, because they don't expect you to be barristers, they don't expect you to be specialists in that area of law. And so having given myself a really good grounding in the basic principles, it came through in the interviews, and I found that's what the panels were often interested in.
Well, I think that's the thing with the legal problems, is that you think it's going to be the highest level of abstraction of these principles, but actually it's just, they're only expecting you to know really the basic principles, but it's how malleable you are with the way that you can explore them and test them and pull them around and argue both sides of it. But ultimately, provided that you have knowledge of the basic bits, that would probably, actually be better than trying to think in too much of a complicated way about it. Do you have any particular highlights from your second round interview experiences?
For me, it was when you felt that you built some kind of rapport with the interview panel, and you actually started enjoying yourself. I had two second round interviews in particular where I really felt like I fitted in and I was getting on with the people that were interviewing me. And although you never forget that it's an interview, really, you start recognising that you do actually have the ability to show the best kind of yourself in an interview. And for me, that was always a nice moment.
I mean, I was quite excited about the second round interviews because I knew that they'd all be legal problems and there was going to be judicial intervention, and that's what I was really looking forward to, because that's where I feel I really excel. I can sit and I can go through my CV, but to actually be able to demonstrate who I am as an advocate and be able to think on my feet and be fast-paced and quick and really match the tempo of the chambers and the area of law I'm going into, that was what really excited me about second round interviews.
Do you feel like it's the truest test of what you're actually going to do?
Yeah.
The danger I found as a GDL student was a lack of confidence in my own opinion, because I hadn't studied family law. I felt that it could be possible that I would struggle to have an opinion. Why should I have an opinion? I'm only a GDL student and these are specialists in their field. But I think it's important to have an opinion because they want to see that you can come to a reasoned, sensible point of view based on the information that you've had available to you, and that you can explain why you have that opinion and, where appropriate, defend it.
That's one of the difficult things, though, is holding your ground when not only are they pressing you, but at times you have that awful conflict because you're thinking, are they actually trying to help me into recognising the correct alternative? And then some interviewers will do the classic kind of, you'll be saying something that you know is correct, but they'll give you a kind of this face as if to say, how could you possibly be saying this?
That's exactly what, as barristers, we will be facing.
Yeah.
We hit courtrooms and that's what they're testing. But yes, I agree, it's very hard to know at what point you think, oh no, I have actually got that wrong. Or, no, I'm going to stick with this, I'm going to keep going.
What was actually one of the interesting things I thought when you mentioned it just now is going and having multi-layered interviews. If you go in and they've told you have to prepare a legal problem, or you've just spent half an hour doing it, and you get completely immersed in the problem, and you have your notes, and as you're walking into the room, you're already thinking about what you're going to be saying about it, and they sit down, or you sit down, and they say, okay, we're going to start with some questions about you. And then you have to get out of the mind frame of the problem and remember, wait a minute, oh yeah, I've done all these experiences, and then you have, so that can be a little bit of a challenge to zone into the legal problem as and when it arises, but still, to be prepared to talk about other things as well.
But I think the most important thing is to go into an interview being a person, as much as a candidate.
Of course.
Well, our main practice areas at 5 St Andrews Hill are crime and other areas which involve a lot of advocacy. So for us, we're obviously looking for people who are going to make good advocates. And so that's why we have an advocacy exercise as part of our interview process.
Madam, Miss Stykes is aware of the seriousness of this offence, and in her own words, she is not proud of what she's done. Consequently, Miss Stykes is appreciative of the fact that she may well incur a custodial sentence. However, I seek to persuade the court that in light of her good character, her early guilty plea and her personal circumstances, that in fact the imposition of a low-level community order is substantial and suitable in a case such as this.
A good candidate has confidence, They're not looking down at their papers, they're looking at the panel who are hearing from them. They know what they're talking about, they're persuasive. That's the most important thing. A plea mitigation in particular is effectively a sales pitch where you're having to sell a sentence to a particular body, and to do that you've got to be good at persuading.
I think if you're anticipating that you're going to get a plea mitigation or some kind of advocacy exercise, it's not to feel daunted by it. It feels quite insurmountable to start off with. You're going to get an unseen set of facts that you're going to get approximately 15 minutes to prepare and then approximately 5 minutes to deliver. That's quite a tall order. I think once you realise, or certainly I did, when I realised that a plea mitigation is itself actually quite formulaic, and there's quite a degree of preparation you can do before you go into the interview, it becomes quite achievable. So, for example, I felt that I could prepare quite a broad introduction and a broad conclusion that was detailed enough to give me confidence, but not so detailed that I then couldn't adapt it to the fact pattern that I was given. But I knew I was going to start strong, and I knew I was going to end strong.
I would say that people who apply and have to do an advocacy exercise should try and remain calm. The people who are hearing you do the exercise recognise that you're going to be nervous and they factor that in. But we're looking for more than just that. We're looking for people that have an understanding of the case, see the important factors that they should have identified, and who are able to persuade us, even if they are a little bit nervous. We often set an ethical problem as part of our interview process because, not that we expect people to get the right answer, but ethical problems do arise, and what we're trying to see is people's ability to think through a problem, to hear them talk through the steps they would take to try and resolve that problem. And often the right answer is that they're not able to answer without going off and getting help from a colleague, which in real life is what you do. But as I say, it's more a case of just seeing people's approach to it, seeing the logic they put behind it, and seeing how they're able to sustain an argument once they're challenged on their point of view.
So in this case, you've been asked to represent Mrs. Albert, who is the mother in a child arrangements case. The mother in this case has demonstrated an unwillingness to comply with orders that have previously been made by the court, and has specifically informed you after the latest hearing that she will not comply with the order as it has just been made. A barrister has a dual duty. A barrister has a duty to their client, always to act in the best interest of their client. A barrister also has a duty to act as an officer of the court. And it's those two dual obligations that inform the professional responsibilities that a barrister has and the decisions that they make. I often find that when in an interview process, those who are asking the questions aren't just interested in the answer that you've come to, but they want to know why you think that way. What were the logical steps in that process? And the first point for me there is to understand the key issue that I have to deal with.
The way we teach ethics is we try and embed different ethical scenarios at different stages of the course as we progress throughout the year. And then we will discuss in class answers or how counsel should deal with those scenarios in a practical way when it comes to practice, but at the same time operating a structure that will help them when it comes to the assessments in Easter.
So the first thing that I would say to anybody who hasn't had the advantage of doing the bar course yet is to make yourselves familiar with that dual responsibility that a barrister has. Personally, on the GDL, I would not have been able to quote the core duties verbatim, as a lot of bar students will be able to. But an understanding of the thought process that a barrister goes through, and specifically the obligations the barrister is under, and perhaps most importantly, why the barrister is under that dual obligation, should, in my opinion, form any response to this kind of question.
Annabel's answer was excellent. She clearly identified the relevant core duty or duties, who she was acting for, and it was a very well structured answer.
I think, Richard, you've had about half an hour to have a look at this problem.
Yes.
And the three questions at the end I'd like you to address. First of all, what do you think the prospects of success in the claim against the security company is? Secondly, what about a claim against Mr. Thompson? And thirdly, and you don't have to deal with them in this order, the third one on the list is, are there any other relevant practical considerations which you would have in mind when advising Mr. Charter?
So the claim is that by directing his horsebox to where they did, it constituted an obstruction, and it was reasonably foreseeable that somebody would seek to move it because it constituted an obstruction, which led to his injuries.
When we set a legal problem question, I think we're looking for the candidate to have the opportunity of exploring a number of different issues. We're much more interested in seeing how the candidate can grapple with the legal issues rather than necessarily get to the right answer.
Well, I actually have different contingencies depending on who Mr. Thompson is in relation to the defendant jail security, because depending on whether he is just a complete stranger or if he's an employee of theirs, which he may be, or an independent contractor, there are different issues to deal with.
So what would be the breach then if you've established a duty on the part of Mr. Thompson, do you think? How would you frame it?
The breach would be... Can I take a moment to consider the breach? Thank you. The breach would be quite simply raising the ramp manually instead of using hydraulic controls, as would be expected by any reasonable person.
Yes, causing a danger, I suppose, to
Exactly.
the owner when that owner comes back.
Exactly.
I think that the candidate we've seen today, Richard, is a very good example of a good candidate. He grappled with all of the issues. He demonstrated that he'd thought through the issues before arriving at the answer. I'm not sure that I would necessarily have agreed with everything he said, but that doesn't matter at all. He sensibly broadened the issues to include a number of other factual scenarios to give himself something more to talk about.